Good morning, members. It is now time to start the meeting, so let's invite the team from the government to join us.
早晨，秘書長，早晨。
Good morning. I'd like to welcome the public officers from the government as well as the Hong Kong MA. I don't think we need to introduce the public officers to you. The Octopus as well as Edenred have made submissions to us, and you can find the papers in CB bracket 1 765 14 to 15 bracket 01 as well as CB bracket 1791/14 to 15 bracket 01 respectively. And the admin has come back with a response, and you find it in paper CB bracket 1836/14 to 15 bracket 01. So I'd like to give the floor to Mr. Liu, DPS. Thank you, Mr. Chairman. We'll set out our reply in the paper, as you have mentioned. For our reply, well, in fact, the concerns have been raised at the meetings of the Bills Committee. So we have, in fact, already given responses. First of all, for Edenred, it fully supports and understands the objectives of the bill, so we're grateful for that. For the Octopus Cards Limited, they are concerned about the possibility of negative balances because currently the Octopus Cards Limited does allow for a negative provision of up to $35. They are worried as to whether this arrangement will be affected by the bill. At meetings of the Bills Committee, we have already said that our provision does not preclude the situation that the rules of the facility provide for a negative provision. For Edenred, as a result of the need of its business, well, it is sort of running e-coupons for reward or for bonus and for staff. So they are worried as to whether such e-coupons will be regulated. For e-coupons, I think they are quite similar to a single-purpose SVF or SVF used for bonus point schemes. In Schedule 8, we have already clearly given an exemption. So when we come to the discussion of Schedule 8, we can revisit the topic again. I think this clarification will assist in removing the concerns on the part of Edenred. Conditions of license, power to give direction, functions of the MA, review of decisions by a tribunal, etc. I think when we come to the relevant provisions, we can sort of elaborate on our replies. I understand that at our previous meeting, we gave a detailed discussion. We had a detailed discussion of Schedule 3, and that's about the conditions of licensing. I think the Octopus would like to have a level playing field for bank and non-bank licensees. And what about other business? Does it require the approval of the monetary authority? We've given a reply, and at the last meeting we elaborated on the relevant provisions. Octopus Cards Limited also said that we shouldn't be over-regulating, in particular when it comes to the redeeming provisions as well as the setting of fee levels. They hope that the market can take the initiative and there will be flexibility. We've given our explanation. We want to make sure that it is prudent and up to standard when it comes to the operation, so that users and potential users will not have their interests being jeopardized. For the MA, when the MA is to enforce the law, the MA will take note of the measures to protect the consumers. We are going to issue guidelines to talk about redemption, deadlines, etc., as well as the regulatory expectations. And the MA intends to issue guidelines. I'll go into the details in relation to the government's position. That's it from me. Members, any questions? No questions? Then I would like to talk about the government's responses to the follow-up actions arising from the discussion at the meeting on the 28th of April 2015. CB bracket 1836/14-15 bracket 03, government. Thank you, Mr. Chairman. There are 3 points that we would like to give supplementary information in writing. First of all, your legal advisor is concerned about Section 7 as to whether there is a penalty on summary conviction. We are grateful to your legal advisor's point, and we will make reference to other comparable provisions in the bill and we will add the penalty. At the last meeting, members, in particular Mr. Sin Chung Kai, is concerned about the proposed Section 8 of Part 2 of Schedule 3, where we say that the SVF issuer has to draw a contract, and the contract must clearly and prominently talk about the conditions in relation to redemption, including if any fee is to be charged for redemption, and any deadline for using or redeeming the stored value that remains on the facility. So the law will say that it has to be clearly and prominently stated. The bill doesn't say and doesn't disallow that the issuer of the SVF can set a fee and can set a deadline. We believe that it is important to impose a disclosure requirement. That is, if there is such a condition to charge a fee or if there is a deadline for redemption, then this information should be given to the consumers so the consumers can choose and we can enhance the protection of the consumers. We understand that in the market there may be SVFs that may be issued for commemorative purpose, and so they may be valid within a specified period only. So the consumers must know about it so that they will use up the value within the validity period. For such a disclosure arrangement, when compared with the requirements in the United States, Singapore, and Australia, we are comparable. We have been asked as to whether we will make reference to the Code of Banking Practice. We have a similar requirement in the existing practice for the multi-purpose cards regime. That is, the deadline for redemption and also policies concerning redemption should be clearly explained to the clients. For our bill, we try our best to make sure that the relevant sector, that is the payment industry, will adopt reasonable business practices that treat customers fairly. Therefore, the MA will consider issuing guidelines so as to facilitate licensees to comply with the relevant requirements in the bill concerning the redemption of the outstanding stored value, including the setting of fees and deadlines. So we'll be telling them about our regulatory expectations. We don't want to have unfair or unreasonable conditions. In fact, according to that schedule, we hope that the licensees will be prudent and sound in the operation so that there won't be any adverse impact on the users. Thirdly, I think there was this question as to the non-payment of license fees by the SVF licensees. According to the bill, if a licensee doesn't pay up the license fees, and despite our notice to demand payment, in fact, the MA may revoke, temporarily suspend a license. When the MA is to issue an order to do so, there is revoke, temporarily suspend the license. Unless the licensee has got something in writing by the MA, the licensee can no longer issue the SVF. The licensee and the former licensee will be breaking the law if it fails to do so. In this way, we hope that we can afford adequate safeguards to protect the interests of the users. Thank you. Mr. Sin, I try to understand. I hope I can. But I think what you mean is that for the multi-purpose cards of the banking sector, there will be a guideline. In other words, we are not going to restrict the redemption deadline. Mr. Sin's understanding is correct. After the enactment of the bill, in fact, the ordinance empowers the MA to issue guidelines concerning the scope of application. So we don't think that it's necessary to have an express provision to disallow the level of fees to be charged as well as the redemption deadline. We believe that such are market practices, and it all depends on the needs of the community as well as the needs and demands of the users. Our overriding principle is that we have to make sure that the licensees will be treating the customers in a fair manner. So the Hong Kong MA intends to issue guidelines upon enactment of the bill so that the licensees, in relation to the setting of fee levels, redemption deadlines, etc., there will be regulatory advice. In this way, we can monitor the protection of customer interests. We do attach a lot of importance to this matter, and depending on the characteristics of individual products, we hope that they will tailor for the needs of the customers. Mr. Sin, I think I understand the point, but I don't think I can quite agree with the government. Last time I tried to draw a comparison. Now you may have a dormant account in relation to bank deposits, and then the bank will impose a fee on you, and gradually the amount will be deducted. So it isn't so much of confiscation. Now, for this payment product, you do allow for a deadline. Now, instead of money being kept in my deposit account, the money goes into this card, and then upon expiry of the deadline, the money will be taken away. I can no longer get it back. Why would you allow this to happen? Yes, you do say that there will be a clearly worded deadline. This is quite unlike other types of service. Service has already been bought, and there is a deadline. But then we're talking about a payment tool. It is like a currency. So it is only through the electronic means that we are making a payment. The money still belongs to me. It still belongs to the card holder. So do we have a deadline appearing on the bank note issued by the Hong Kong MA? Of course not.
Thank you for the question. As I mentioned just now, the proposal in the legislation does not prohibit or encourage the license holder to establish a deadline for redemption of the stored value. We are aware that the majority of these products do not set a redemption deadline, and we have considered that in the market or other places there might have been stored value facilities issued on a commemorative basis. There might be a special edition for tourists or special users, and they might have a deadline, an expiry date, a valid date, but usually the stored value facilities don't have a deadline. But if we have a special edition or special product with a deadline, since these are not regular occurrences, then they need to notify the consumers such that consumers are aware that there is a deadline for this product. Before you purchase this, you have to consider whether this product suits your purpose. So under these circumstances, we can allow for deadlines, but we are aware that normally in the market there aren't deadlines. If we allow more flexibility for the market, and if there might be some advantage to not setting any prohibitions on deadlines, but we're willing to listen to opinions. Chairman, let me persuade you. Well, I feel, can we take the approach where normally you wouldn't have a deadline if the operator, they can persuade the monetary authority to get a special permission, and then they can only issue a stored value facility with a deadline. For example, you issue a $100 banknote, and then somebody wants to issue a $150 note. They have a commemorative purpose. Well, I don't want to be business unfriendly, but when we safeguard consumer interests, we should give you the authority. You need to provide full disclosure, and we allow you to set a deadline. Otherwise, you should only permit them under very special circumstances. Other countries require disclosure. I don't believe that strengthening disclosure is sufficient, unless you can convince me that it is not a currency. Well, if it's a currency, why should it have a deadline? Thank you, Mr. Sin, for your recommendation. We will look into that. Tan Jishan. My thinking is similar to Xin Zhonggai's. I think the majority of these SVF should not have a deadline for stored value. They should not expire, and they should not have a large administrative fee for a redemption. Now, Chairman, you said just now that normally there isn't an expiry date, but do we have examples of where they have expiry dates? I understand commemorative tickets, for example, MTR, you can only use it on the first day of the lunar year. So that's one example. But our SVF under this definition is not a single use tool. It's not to be used in a movie theater for one show. So it's for general use. So even if you quote a commemorative reason, you can only use it on a certain festival, a certain day, or a certain period. Should we just issue an SVF for a special period? Do we have examples of these in real life? Well, we've heard members' views. Yes, we will look into this. A legal advisor has some comments. Well, the follow-up is that if you look at the legislation, let me read it out. Which clause are you quoting? Which page? C444. C444, it's in the schedule. The if you're referring to the markup copy, it's page 193. The minimum criteria. Unless otherwise provided in Part 2 of the schedule. Now, if we just look at A, there is no time deadline. That's the largest principle. If we allow them to issue, and if there is a deadline for redemption, they are already contravening A. Well, I understand having some flexibility, but that is just a expiry date of the tool. That's not redemption. We're not talking about something similar to electronic currency. If you have it in a SVF, it's like an electronic bank. So it's very similar to currency banks. And whether you're talking about the deposits, there wouldn't be any expiry date on withdrawal. So they should not be allowed a deadline in B. If you're having a deadline, it's like having a deadline for withdrawal from a bank, and that's not allowed. So if you have a deadline in redemption, in other words, you're allowing them to confiscate. So if they have that in 8, if they have done that, then they are contravening 8A. Secretary, thank you for your opinion. I've heard Mr. Chan, Mr. Sin, and the legal advisors' viewpoints. So we repeat that the issuer will treat the customers fairly and will disclose, and their operations should not adversely affect a consumer interest. So we will look at how we can draft Clause 8 better. We will look at Mr. Sin's comments. That is, there should not be a deadline for redemption. That we would need the authorities' permission before having a deadline. So we'll have to safeguard consumer interests and also balance business operation needs. So we need to strike a balance between the two. Thank you, Chairman. Regarding the SVF license holder, they need to pay the license fee. If they don't pay the license fee, they could have the license suspended, revoked, and so on. How do you safeguard consumer interest then? Thank you, Chairman. If there is a revocation or temporary suspension or suspension of license, when the monetary authority issues these decisions, they will consider the rights of consumers and how they can be safeguarded. When the monetary authority issues these instructions, the license holder, when necessary, can refund the outstanding value to consumers, and they will also have some arrangements for the business operations, so where they do not enroll or have new subscriptions, the existing customers can use the remaining value. So in revocation, temporary suspension, and suspension of license, they will consider that as a whole. So they might be, the license holder might be allowed to operate certain portions of the business to satisfy consumer needs. So if we don't have any other questions, we can enter Clause 17, that is Part 2A Clause 8, 8A. The markup copy, page 36. If you have the markup copy, it's page 36 in the Chinese version. If you're looking at the blue bill, it's C140. We are now at 8Q. We want to ensure that after the license has been issued, so all the license criteria are fulfilled. In 8R, we have to refer to the banking ordinance clause 67 to ensure that the license holder might not be able to fulfill its conditions, or they might have to seize payment. They need to report to the monetary authority as soon as possible. The regulatory procedures regarding the license holder will have to ensure that the business can continue, and we require them to report to the monetary authority as soon as possible. If they cannot fulfill that, it's a breach of the law. 8S requires the license holder, if they have any changes, that is 8E3B, that is its business premises or mail address or email address has a change, then they have to report to the monetary authority within 6 days of the change, such that the monetary authority will be aware of the business address and operations. If they cannot fulfill this, it's also a breach of the law. Let me pause here. 6 days, is it calendar days or is it working days? Chairman, the 6 days are calendar days. So if you don't say working days, you can understand it as calendar days. We can confirm with the draftsman. Unless we say working day, otherwise it's understood as calendar days. Please continue. 8T, we require the license holder, if they continue to comply with the license requirement, or if they comply with the license criteria, or if their business continues to issue SVF, and if there is a possibility of substantial change, they cannot postpone. They have to, within a reasonable period, notify the monetary authority to facilitate the regulatory work. So this is also applicable in the banking ordinance. Mr. Mlung Sing, regarding a reasonable period, if you refer to 8S, they mention 6 days. So this reasonable period, shouldn't we give them a date as well? Otherwise, we might have to exercise discretion and so on. Do we need to specify a period? 8S is very concrete. It says if the 3 criteria, the email address, the correspondence address, and the business operations change, then it's very clear to identify the change. So we can say they need to notify the authority in writing within 6 days. But just now you were referring to 8T, 2B, where the licensee, they continue to comply with the licensing conditions, or if their business is likely to undergo substantial change. there is some uncertainty, but they foresee a large possibility of change. We feel they should notify the authority within a reasonable time. They have to notify the monetary authority. So this is slightly different from the change of address just now. It's very concrete. This would involve some judgment, and we feel that in order to give the regulatory authority and the licensee some flexibility, if they can notify the monetary authority within a reasonable time, that can satisfy the regulatory needs. If we set a fixed date, that might lead to some discrepancy in expectations between the licensee and monetary authority. So we feel that the current arrangement is acceptable to the licensee. Thank you, Chairman.
But
then I'm a bit worried. We talk about within a reasonable period. Then you can be generous and you can give the issuer 14 or 21 days. But at least you need to name a time frame. A lot of things can be regarded as a material change. So it will be difficult to exercise discretion. So there will be flexibility and discretion. I think it's better to define it in the first place. Do we have something similar in the existing law? Yes, we do. In the banking ordinance. I can go back to look up the relevant information. I agree with Mr. Ng. That is, maybe there will be too much flexibility for the licensee. We'll certainly go back to see whether we should expressly provide for a definitive period so as to facilitate enforcement on the part of the Hong Kong MA, or whether it is better to have it accommodated in the guidelines. I'll certainly talk to the enforcement agency and will come back to the member next time. Any other questions? I think that's it for HT, and then Division 5, Revocation and Suspension of License. I would like to defer to Ms. Lee. Thank you, Mr. Chairman. That's about revocation and suspension of license. For HU, earlier on under HG, a bank will be regarded as a licensee. So if a bank has its banking license revoked, then the status of being a licensee will also be revoked. HV, revocation of license on grounds specified in Schedule 5. The MA has to go through a certain process. We have made reference to Section 23 of the BO. I'll try to cover the process, and then I'll talk about the grounds specified in Schedule 5. First of all, if the MA is satisfied that a ground for revoking a license specified in Part 2 of 3 of Schedule 5 exists, the monetary authority may give a written notice to the licensee stating the MA's intention to propose to revoke the license and the ground for doing so, and specify in the notice a period of not less than 14 days within which the licensee may make oral or written representations to the MA. If the MA, having listened to the licensee, maintain the decision, then it has to give the ground for the revocation. Having given a notice of proposal to revoke, the MA must give a notice to the licensee as soon as practicable after the following factors. And this is a notice of revocation. A. The licensee has given a written notice to the MA stating that it does not intend to refer the decision to propose to revoke the license to the tribunal for review under Section 351, or the period for review has already expired, or the review has not been successful. Then the notice of revocation will come into effect on the date named or specified. The MA will, as soon as possible, publish a notice in Chinese in one Chinese language newspaper circulating in Hong Kong, and a notice in English in one English language newspaper circulating in Hong Kong, each stating A. the name of the licensee, B. the fact that it has been revoked, and C. that the revocation is to take effect on the date or the occurrence of the event specified in the notice. Would you say that giving a notice on the website of the Hong Kong MA, if that is to be done, can you do away with the need to publish a notice in 2 newspapers to protect the interests of the consumers? We will certainly issue a press release, and so there will be an announcement on our website. But then to play safe, we'll also like to publish a notice in Chinese in a Chinese language newspaper, and in English in an English language newspaper. Mr. Chen Kim-po, Mr. Chairman, we used to publish a notice in a Chinese language newspaper and an English language newspaper. Now time has changed. Probably many people don't buy a newspaper, and you won't put a notice in the free newspaper. Would you consider whether this is still an effective way to communicate with the public? Thank you. We know that there are many ways to communicate with the public, and we do appreciate that time has changed and newspapers aren't that popular, but we still insist on placing a notice in a Chinese newspaper and an English newspaper. I think this is the minimum that we need to do and can be done. Of course, we understand that the payment products, that is the SVFs, are so popular on the internet, so we'll be placing an announcement in our website. And in fact, when we revoke the license of a SVF, I'm sure the market will get the news, and the Hong Kong MA will also come forward to explain the matter. We'll make sure that the market understands the matter and know about it. But I think it's good to maintain our practice of putting a notice in the newspapers. Mr. Chen Kim-po, when the Hong Kong MA issues the notice, will there be a press release as well? Yes, maybe Mr. Lee can explain. For a matter as important as this one, that is revoking the license of a SVF, it is something major, so there will be a press release, and we will also have the press release release on the website. We will inform the public as soon as possible. What about inviting the internet radio to cover it? We have our own practice of issuing press releases. That is, we will invite the major media as well as all sorts of media to cover the news. Mr. Sin Chung Kai, I don't have strong views as to whether there should be notice in the newspapers. I won't query it if you are to dispense with it, and even if you have it kept, I won't say that it's superfluous. But then, of course, we have to move with the times. I suspect that for such SVFs, I'm sure they have a certain degree of visibility on the internet. Say they have their own websites or their apps. I just wonder if you will require the SVFs within a period of time, say within 2 to 3 days' time, release the news on their own website. I think that's more effective than having a notice in the newspaper. Now, you may have a press conference, but then the users may not have noticed that news item. But then if a user is using the SVF, then I think it's better if you insist that an announcement should be made in its own website. I think that's more effective. Otherwise, I would say that having it on your own website is just a formality. Thank you, Mr. Sin. Well, for HX, we do empower the Hong Kong MA to deal with the float as well as the SVF deposit. So we empower the Hong Kong MA to impose conditions on the use of such things. And the Hong Kong MA may also give directions as to how such value can be used. So we can certainly accommodate Mr. Sin's proposal, that is, the licensee must on its own website or on its own apps make a certain announcement. So I'm sure such a operational matter can be accommodated under provision HX. Legal advisor making a submission to the Hong Kong MA orally or in writing. Will the Hong Kong MA, will the MA himself be hearing the representation, or will it be up to a particular panel? Can there be both oral and written representations instead of just or? Mr. Liu. Mr. Chairman, I think certain functions of the MA can be delegated. It depends on the circumstances, whether it will be the MA hearing the representations himself or delegating it to somebody else. But in any event, it will be effective and valid. No questions? Then we can continue. Ms. Lee. Thank you, Mr. Chairman. Perhaps it's better for us to go to the grounds in Schedule 5, page 448 of the Chinese version, C449 of the English version of the Blue Bill. For this schedule, we have made reference to Schedule 8 of the Banking Ordinance. In Part 1, we have the definitions. Part 2, the grounds of revocation. Sections 3 to 19 are relevant. Now, Section 3, the MA is satisfied that the licensee does not fulfill any of the minimum criteria applicable in relation to the licensee, then it can form a ground of revocation. For Sections 4 to 6, if the MA is satisfied that the licensee is insolvent or it is in the process of a voluntary, or it is winding up, or if the MA is satisfied that the licensee is unable to meet its obligations or has suspended payment, it is a ground for revocation. Sections 7 and 8, the MA is satisfied that the licensee has not provided the MA with any information required to be provided that is of a material nature relating to the licensee or any circumstances likely to affect the licensee's method of business. And then before, on, or after the grant of the license, if the licensee has provided any information that is false, misleading, or inaccurate, then it can also constitute a ground of revocation.
9 refers to the authority is satisfied that the licensee has contravened a condition under Section 8I. The authority can revoke the license. Please wait a second. Oh, I know the legislation is rather dry, but what methods do you have to identify that they are about to run into problems, that they can't pay their debts? We will have a regulatory review. Of course, they need to provide financials. We call these off-site examinations. But aside from off-site examinations, we also have on-site examinations. We'll visit the company. We'll examine their financials. So it's similar to the regulatory framework of banks. We have on-site and off-site oversight. So not only do they have to provide audit information, they also have to provide the business model and other operations information. So we are confident that if the company has problems, we are confident that we can identify them at an early stage and undertake necessary measures. I know you have on-site, off-site investigation, but these stored value facilities, their customers deposit the money in the facility, and the SVF company would have received instructions and forward it to a merchant, and they would charge a commission. So theoretically, the company's finances, they would have a separate account for the customer's funds. Well, my question is, it would be ideal if you had some red flag warnings. So aside from on-site, off-site, what would set your alarm bells off? Thank you, Chairman. In our regulatory framework, the SVF funds need to have safeguards. First of all, the funds have to be in a segregated account, and the float needs to be placed in a fund, or they need to ensure that the whole sum is safe. So when we manage the float, this is something that we have to consider. The first thing we consider. So in our whole regulatory exercise, we will examine the segregated account. We'll make sure the money is in the segregated account, and we'll look at what safeguards they have. So these are the minimum requirements. So if they cannot comply with our requirements, then this is a clear warning that the company has problems. Okay, let's continue then. The other reasons for revoking a license include the licensee has failed to pay the fee, it has stopped operations, the authority had informed them to pay the fee, but they have not continued to pay the fee. They contravene Hong Kong's position as an international financial center. They have not paid any fines, and so on. In Reason 11, you're saying that there is Section 8M, 8N. Well, 8M does not belong to the banking ordinance. 8N is the part of the banking ordinance, and you say that if in 8G the licensee has certain requirements. But banks do not necessarily engage in SVF, but you view them as SVF operators, and they will levy them a fee of 113,800. Well, they have to engage in that business, and we would levy the fee of 111,000. So if they don't engage in that business, they do not need to pay the levy in Schedule 4. Well, if you view banks as licensees, but then they have to pay the levy before they can enter operations, why can't you have an arrangement where they have paid the levy, then they would be considered as a licensee? Well, banks, under the banking ordinance, they already are subject to regulatory monitoring, and some banks might be already engaged in this business. So, under the banking ordinance issue of license, there are very stringent requirements. So, if the bank if it wishes to engage in a certain business and have to apply again, it's an overlapping of procedures. So we feel it's not necessary, and we don't see that all banks would engage in this business. So we feel we can view banks theoretically have received a license, but if they want to engage in this business, they would have to apply. They would have to pay a levy, license levy under 8M, and they do not need to go through the assessment procedures. They don't need to set up a company and so on. So if they want to do the business, they just need to pay the levy. It's most convenient to the industry and the MA. Well, debit cards are not that popular in Hong Kong. So if, let's say, a bank wishes to issue a debit card, so do you view that as a SVF or a payment tool? How do you view that? Let me explain. If we have debit cards, we would view that as a part of a banking function as within the bank. It's not viewed as a stored value facility. Please continue. The last is part 3, where the licensee requests in writing the monetary authority to revoke the license, and the monetary authority is satisfied. We can refer back to 8W regarding revoking of license. C 105, the C150, they cannot charge any fees, and unless they receive the monetary authority approval, they cannot retain deposits. If they breach 1D, if they hold deposit and it's a breach, 8X refers to the monetary authority may give consent to hold float and SVF deposit after revocation of license. The monetary authority, when they give a written consent, they can also apply conditions or repeal certain conditions. The conditions can also specify a designated person and what deposit they need to hold and so on. Well, this can accommodate Mr. Sin's suggestion just now that where the license has been revoked and they still need to return the outstanding amount, or they have to allow consumers to use the outstanding amount. So we have given the monetary authority the power to allow certain parts of the business to continue operations, and this can also have conditions attached, and that would include Mr. Sin's suggestion that perhaps they need to have a notice in their website or app, and they need to facilitate the consumer consummating the transaction as soon as possible. That can be dealt with in 8X. Legal advisor. Going back to 8W, I had asked in writing, we see brackets 1A to D, they are not allowed. The license are also, after the license has been revoked, they cannot certain activities are not allowed. And we also see that in 1C there is a criminal sanction as a criminal offense. But do we have reasons why they are not criminal offenses? Is the legal advisor referring to 8W? Thank you, Chairman. In clause 1D, unless there is written consent, the licensee cannot hold the float or deposit. This is important. If they consider to hold on to the float or funds, we understand that. But what about A to C? A to C says that if the license has been revoked, they don't have a license. If they operate without a license, they already would have breached the law. So we don't need new penalties for A to C. I have nothing more to add, Chairman. Next, we move on to 8Y. 8Y deals with suspension of license. Since under the banking ordinance, the bank is viewed as having a license, and if there's a temporary revocation, and a license regarded as granted to a bank under Section 8G is suspended, while the banking license held by the bank is suspended under Section 24. 8Z deals with temporary suspension of license and what conditions have to be complied with under the monetary authority. For example, in 8V, a written notice has to be issued, and the licensee needs to have 14 days. There has to be urgent actions, and there has to be a designated date and reason. Please continue. Mr. Sin Jong-gai. Well, banks are not required a new license, and you view them as a license holder in 8G. But the banking business is no problem, but if they are not allowed to conduct payment services, so under these, what licenses would be revoked? What would be revoked? If this situation as Mr. Scenario described occurs, then for the licensed bank, the SVF business, we can apply 8Z or 8A and to suspend temporarily the SVF license. 8Y says that if the banking license is suspended or temporarily suspended, then all the banking I understand. If they don't have a license, they can't do SVF. But if the bank doesn't have problems, but they have, and the payment system has problems, how can you deal with that? We can apply 8Z or 8A and have a temporary a suspension of license in portions or of their business, or suspension of 6 months, or ZA has a suspension of 6 months. So you'll have a perpetual suspension of 6 months.
Can it be perpetual? Mr. Sin's understanding is correct. If during the period of suspension of license, and if the MA cannot be satisfied, then the temporary suspension can be renewed. But I don't think that it will be suspended or temporarily suspended forever. I think in actual operation, the longer this remains the case, the licensee can no longer carry out its business, and it's a matter of inability to pay, and then it will constitute a ground of revocation. I don't think the Hong Kong MA would not be suspending or temporarily suspending the license forever. I think the MA will act decisively. If it is found that in the long term the licensee is not appropriate to carry out SVF business, then the MA will ask the licensee to finish with the business and withdraw from the sector ASAP. Mr. Sin, let me cite some examples. We may have a hacker leaking the client list, so it will become the headline news. You find it on page A1, and then the security will be questioned, or there's a hacker stealing the money. Now, this is the payment business, and this is different from the operation of the banking business. You may be good at the banking business, but then you may not be equally good at the SVF business. So when something happens, you don't want it to carry out the payment business, but you have no power to revoke the license. Will it be suspended time and again, or will you wait until you can be satisfied and then you will remove the revocation or the suspension? Now, for the bank, it may be fine as far as prudent banking business is concerned, but then for the payment business, it is more about the technology. Mr. Lee. Thank you, Mr. Chairman. Thank you, Mr. Sin. Well, a bank may be fine with its banking business, but there may be a problem with the payment business. In this case, we can revoke the license, and it has to satisfy us that it can resume the business or before we can give back the license. Now, in the case of suspending the license, after it has been suspended, then the business can no longer be carried out. When it comes to suspension, it means that we try to buy time so that the money of the customers can be orderly refunded. So for a bank licensee, the license can be revoked. But you haven't got a specific license. So what are you going to revoke? Mr. Lee. Well, in the process, the bank will have power to do this business. When they choose to do this, then a license will be given, and they have to pay for the license. Therefore, there is a license for us to revoke. I can't understand. Please continue. HZB, quite similar to HW. So, during the suspension of license, the licensee can no longer issue or facilitate the issue of any stored value facility. The only difference is that it has to continue to pay the license fee. And then for the Hong Kong MA, in relation to the powers to control the licensee, the powers will be the same as before the suspension of license. Obligations and duties on the part of the licensee will still be valid. HZC, similar to HX. So the MA may, during the suspension of license, agree that the licensee can hold the float or the deposit of the SVF. HZD that belongs to Division 6. Let me continue. Division 6 is another division, and we need to give some powers to the Hong Kong MA over management of licensee. This is important for regulation. Mr. Sin asked, in the event of a problem, he would like to know what powers the MA has got. Say, for example, when there's a crisis or insolvency. We do have a few important provisions copied from Section 52 of the Banking Ordinance, which we believe are also applicable to SVF licensee. Well, Section 52 of BO means that banks are already sort of covered. Therefore, we say that this division does not apply to a licensee that is a bank. In other words, it applies to a licensee that is a non-bank. Section 52 of the BO will apply to the bank licensees. Now, there are three powers. First of all, the MA may issue a directive that you find it in HZF, so to take immediate action. HZG, the power to give direction for licensee to seek advice on management of its affairs. The MA will in fact be appointing a consultant or an advisor. HZH, in fact, a manager will be appointed to see if the business can be rescued. As to under what circumstances are we going to make use of the reserve powers, under HZE, it says that when certain scenarios arise, say for example the licensee tells the MA that it is insolvent, or the licensee can no longer carry on its business and it can no longer meet the obligations to pay, and you will be suspending the payment, or it is found that the licensee is doing something which jeopardizes the interests of the users, or it is breaching the licensing conditions, then it means that the MA can make use of the powers in HZF, HZG, and HZH. Now, for the first one, immediate action, you find it in HZF. There will be certain restrictions to be imposed. Failure to comply will attract a penalty. And then the MA can also appoint a manager or an advisor. So the licensee has to turn to the advisor for assistance. For the following one, that's about the appointment of manager to help with the management. Again, the direction issued by the Hong Kong MA must specify the affairs, business, or property, and other things, and the MA must set out the objectives. Usually, one of the objectives will be to safeguard the rights and interests of the consumers, or to improve the financial situation of the licensee. Usually, this means that when something major happens, when it is on the verge of insolvency, then the MA has to act decisively, and we need this power to intervene. For HZI, it means that the advisor or the manager may be a corporation, a partnership, or a person appointed under Section 5A3 of the Exchange Fund Ordinance to assist the MA. For the banking industry, we have the BO. In rare circumstances, the MA has also had experience of appointing someone from a law firm or accountancy firm to deal with a bank that has gone into trouble. Sorry, speaking off mic. Mr. Sin Chung Kai. Do you require the licensee to be somebody ordinarily residing in Hong Kong? We are afraid that if we have got a global citizen not always residing in Hong Kong, then is it possible for you to locate him? Yes, you are right. HZZU, if we do come to that, it will require the chief executive has to be somebody who is an ordinary resident in Hong Kong. So you won't have the scenario in which you can't locate the chief executive. Will certainly require the chief executive to be an ordinary resident. Well, when such organizations go into trouble, of course the financial problems are huge. But then the accountants, say for example, will charge an exorbitant fee. Can you do something to make sure that the management fee will be kept at a reasonable level? Otherwise, you are aggravating the problem. I think it's better for you to use it as a last resort. If they can deal with the problem themselves, let it be. And also, you make the appointment who's going to decide on the fee levels so that it won't be pitched at an exorbitant level. Under HZZ, we do talk about the remuneration and expenses of advisor or manager. The MA has to consult the FS and then determine the remuneration or expenses to be paid by licensee to the advisor or the manager. So it requires the agreement of the MA after consulting the FS. In fact, we do have reserved powers to say that the MA, after consulting the FS, may use the exchange fund to pay for the remuneration or the expenses, wholly or partly. So there is a mechanism to deal with this issue. The same mechanism applies to the banking ordinance. Subdivision 3. The manager has got huge powers, so we believe that we need clear provisions. When the MA appoints a manager, then there must be a notice to be published in Gazette that's provided for under HZK, and then the public should be notified to tell the public about the matter. HZM, effect of direction. The original chief executive and the directors, the appointments will immediately be revoked unless at the time of giving the direction this is being exempted. Otherwise, when we have got a manager or administrator, then the CE as well as the director will be regarded as having the appointment revoked, and such persons may no longer act in such a capacity. HZN. Once a direction has been issued, unless with the agreement of the manager or in the presence of the manager, otherwise they cannot have the general meetings, and then they can only endorse resolutions or proposals with the agreement of the manager and the presence of the manager, so as to make sure that all the assets and the business can be taken over by the manager. You'll find a similar provision under Section 53B of the BO.
In HZO, we have a series of legislation that describes the power of manager. So members could refer to Schedule 7. page 200 of the markup copy and page 458 of the blue bill. So these are made, they had made reference to the banking ordinance. The banking ordinance has legislation to deal with powers of the manager of licensee. We have made reference, for example, the manager has power to take possession of, collect, and get in the property of the licensee concerned, has the power to purchase property, power to sell, power to raise or borrow money, power to write checks, and power to continue operations, or power to repay debt, or change business address. And if there is insolvency proceeding, they have the power to do so. So all these are copied from the banking ordinance. Well, the name powers of manager of licensee, if you just look at the name, it refers to the monetary authority manager. So shouldn't that reflect this arrangement? Because if you just look at it, it sounds like the licensee's manager. Well, we mentioned the term manager before. If there is a crisis, a consultant or professional is appointed to deal with the company's assets. So there is a connotation of taking over the business. We have made reference to banking ordinance, and they had used the capital M manager. In the Chinese, we refer to 管理人, and that has borrowed from the banking ordinance. Well, I feel whether it is 管理人 or controller, the meaning is clear. That is, according to the monetary authority instructions, they can manage the affairs and property of the licensee. So you could use the terms or described by the insolvency officer, but this current drafting should be acceptable. Please continue. Next, after examining Schedule 7, we have to come back to 8ZO. The powers of the manager can control the company, and in Clause 2, the manager may call any meeting of the members, directors, or creditors of the licensee, and the CEO, even though has been dismissed, but the manager needs to be able to conduct the affairs of the business in an orderly fashion, so we allow the manager, we allow the monetary authority to appoint a new CEO or appoint a member of the board of directors, or to put forward motions in the board of directors. So this is made in according to Clause 6. We also have to ensure, we also have the manager may delegate duty and power in 8ZQ. If we have less than 100 members of the licensee or the manager of the licensee, they can seek rulings from the court of first instance, where if they can launch an appeal with the court of first instance and have the court approve resolutions. So this is made reference to 53D of the Banking Ordinance. It applies to the manager and members of the licensee. The court of first instance may make certain orders under 8ZR in order to safeguard the user's interest, and we also require the manager to exercise his duties. So the court of first instance can issue certain instructions to the company. Well, Chairman, I have a question. What do we mean by members? We have shareholders, we have users, and so are we referring to shareholders or users when we refer to members? Well, thank you, Chairman. Your Chairman's understanding is correct. Members refers to shareholders, the company shareholders, those who hold shares. It has a clear definition. Please continue. In 8ZS, a person must not willfully obstruct, resist, or delay a manager of a licensee in the lawful discharge of the manager's duties or the lawful exercise of the manager's powers in respect of the license. So, if they do so, there's a breach of law. The monetary authority can also issue instructions. If necessary, the monetary authority can amend the instructions. That's 8ZT, variation of directions. 8ZU, when the monetary authority has issued an instruction, since they can issue an instruction to appoint consultants or managers, after consulting the financial secretary, they can revoke the direction. So that is the requirement of 8ZU. 8ZV is the same. There can be a revocation of appointment of advisor or manager. We need an advisor or manager, but the appointment of such advisor or manager can be revoked. 8ZW allows the advisor or manager to resign. 8ZX relates to appointment to fill vacancy in office of advisor or manager. 8ZY refers to advisor or manager may engage technical or professional persons to exercise their duties. These advisor or managers can be monetary authority staff. So under Section 5A of the Exchange Fund Ordinance, the person, the advisors or managers can appoint persons under Section 5A3 of the Exchange Fund Ordinance. The monetary authority, after consulting with the financial secretary, can determine the remuneration expenses of advisor and or managers, and they have to notify the licensee as soon as possible. So if necessary, in the monetary authority, after consulting the financial secretary, can use the exchange fund to pay the whole or part of the remuneration or expenses payable. Chan Ginbo, you have said that after consulting the financial secretary, they can pay the remuneration, but there's no mechanism where if you don't have a tender process, then of course they will use the highest price. How do you ensure that the fees are appropriate? In your last paragraph, you have referred to the worst case scenario where they don't have money to pay and they have to be paid through the exchange fund. But what is your normal practice? So the company is already insolvent and they still have to pay large fees. So we see that in handling insolvency cases, the management fees are very exorbitant. In this section, when the situation occurs, it would be very urgent. If we have a tender, time would not allow for that. The MA has experience. They have sum in mind how much to pay, and we can also appoint our own MA staff to do this work and to minimize the expenses. But in the whole process, we feel that tendering is not feasible time-wise. It will not generate unreasonable fees. Well, I assume you will make sure it's reasonable. But when you appoint your MA staff, what arrangements do you have? Some people are worried that MA staff might be even more expensive. Well, if we appoint our own staff, in the process, we might need to charge them, but it will not be an exorbitant fee. Regarding remuneration, after appointing a manager, the CEO will have to be dismissed. After dismissal, does that mean the employment contract is also seized or revoked? So if there are any claims, or if there are any lawsuits, can they be settled, or does it have to be settled in court? Thank you, Chairman. Just now I had mentioned that if a manager is appointed, then according to the instructions, the original CEO or appointment of director would be revoked to ensure that the manager can take over the operations of the business. So that is an exercise of statutory power. This power can also override the contractual requirement between the CEO and the company. So, but the employment contract, if they want to seize the employment contract, there might be penalties, and we see that in employment contracts. So, in my explanation of Schedule 7, there are a wide range of powers for the manager to maintain the operations of the company. The manager can act in the name of the licensee to deal with lawsuits, or the manager can act on behalf of the licensee to arrange for debt repayment. So all these clauses allow the manager to act on the licensee's behalf. So that should be sufficient to deal with a revocation of the appointment of CEO. It could also handle penalties incurred in the employment contract. The manager can act on behalf of the licensee. Please continue. We move on to Division 7. we need to provide powers to the ownership and management of licensee, including the majority shareholder, minority shareholders, or indirect shareholders. They can agree or disagree because who is the owner of the business? It's very important to the operations of the business. In the banking ordinance, the MA can also have direct powers on the majority shareholder controller or minority shareholder controller. So we have borrowed from the relevant sections. 8ZZA, majority shareholder, refers to a corporation or person who has more than 50%. A minority shareholder has a person who either alone or jointly with an associate is entitled to exercise or control at least 10% but not more than 50%. An indirect controller has definitions. It means a person in accordance with whose directions or instructions. So these are all borrowed from clauses 6970 of the banking ordinance, and it's applicable to the banks. So in 8ZZB, to avoid overlapping, we have it does not apply to the licensee that is a bank. Let me continue.
For HZZC, we have made reference to Section 69(2) of the BO. That is, if there is the sale or disposal of business, wholly or partly, on the part of the licensee, first of all, they have to notify the MA, and unless with the approval of the MA, such cannot be done so as to safeguard the interests of the users. If they fail to do so, there will be a penalty. HZZD, again, having made reference to Section 69 of the BO. In the case of reconstruction of its capital, the licensee must notify the MA of the details. So it is a matter of a notification requirement. Subdivision 3. We make it clear that the MA may give a consent notice or an objection notice so as to control the controller. The controller means a majority shareholder controller, minority shareholder controller, or an indirect controller. Within 3 months of having gathered all the documents, the MA must decide on giving the green light or not. HZZF, if somebody is to become a controller of a licensee, then a written notice must be given to the MA so as to keep the MA informed. Under subsection 3, the MA may require the person to provide additional information so as to enable the MA to deal with the to process the information. And then lastly, the MA must issue a consent notice or objection notice. And the decision may also be referred to tribunal for review. Any non-compliance will attract a penalty. HZZGH. If the controller doesn't know that all out of a sudden he becomes a controller. Say, for example, at first he doesn't have sufficient shares to become a minority or majority shareholder controller, but then as a result of changes in shareholding, somebody becomes the controller. Then again, when he becomes aware of it, notification should be given to MA within 14 days. The MA may also give a consent notice or an objection notice or require the person submit more information so as to enable the MA to deal with the application. The MA under H8ZZH, well, if somebody becomes a controller, the MA may impose additional conditions. An initial notice has to be given. A preliminary notice has to be given to that controller, setting out the conditions as well as the grounds. There will be a month's time for that person to make oral or written representations to the MA. Upon completion of the representations, the MA must take everything into account and then come back with a decision. That is whether the MA is going to impose additional conditions on that person becoming controller, and when that will come into effect, the controller must meet the requirements in the consent notice before taking up the post of being a controller. Sin Chung Kai. Well, usually we're talking about corporations which are listed companies, so they may not have independent even the CEO is only an employee. So what do you mean by controller? Well, if the licensee is a listed company, if nobody has more than 10% of the shares, then it means that there won't be any specific controls over the creditors. But then later on, for the CEO and also the senior officers as well as the employees, there are certain requirements. That is, they have to be fit and proper persons, and the chief executive must have the prior approval of the MA. So we have layers of control. If we have got a family in control of the business, you need our approval if we have got more than 10% of the shares. But then if it is a listed company and we have a large number of shareholders, we'll still have some control by way of giving approval to the CEO and senior officers. Say, for example, we have an international company which is listed, and then it may set up a Hong Kong company to provide SVF business. But then it is listed in the US. You can't control the shareholders or controllers. You can at most be controlling the CEO in Hong Kong. Yes, I agree. Say, for example, they may have a major shareholder, and you don't think that he's a fit and proper person, but he's out of Hong Kong. You can refuse to give license, to grant a license, correct? We may very well be talking about a indirect controller that requires MA's approval. When we grant a license, we have to consider who are the controllers, and that will have an impact on whether the company can carry on its business while meeting the licensing conditions under Schedule 3. Schedule 3 also says that each and every chief executive, director, and controller must be fit and proper persons. If that cannot be established, then according to Schedule 3, Part 2, Section 3, Hong Kong MA cannot grant a license. Yes, please continue. Thank you, Mr. Chairman. For ZZI, that's in relation to Section 70, Bracket H of the BO. If there is an objection to any particular person becoming a controller, the MA must make sure that the person involved is a fit and proper person. If not, then the MA can object, and then approval to allow a person to be a controller may jeopardize the interests of the user or the potential user. This will be a very important factor to be considered. Now, a person may not presently be a controller, but then having regard to the person's likely influence on the licensee, if the person were to become such a controller, that the licensee is likely to continue so carrying on business, then there will be objection. If the MA objects to a person becoming controller under HZZI 3, there must be written notice, sufficient time should be given, that is 1 month's time should be given to make oral or written representations as to why an objection notice should not be given. Lastly, the MA will make a decision, and the decision has to be notified to the person who has been objected to, and the decision can be reviewed by the tribunal. Please continue. HZZJ. This also applies to the scenario I have outlined, that is for an existing controller who has already been approved. If this existing controller acts in such a way and is known to the MA to make this person no longer fit and proper person, or the way that this person conducts his business will jeopardize the interests of the user, or the person has contravened a condition attached to a consent notice, then the MA can still give an objection notice to that person. Again, a month's time must be given to allow the person to say why an objection notice should not be given. HZZK. We may have indirect controllers. MA may give an objection notice. If the MA is to give an objective notice saying that a person cannot be an indirect controller, then this person is called a prohibited person. If he is a prohibited person, he can no longer give direction to the directors of the company, because he may be somebody behind the scene. If the MA disapproved him to be an indirect controller, if he continues to influence the company, it means that the CEO will be experiencing a lot of difficulties. Therefore, we have expressed provision to say that if somebody is already regarded as a prohibited person, he can no longer issue directions or instructions. If we continue to do so, he is breaking the law, because he is not being allowed to act as an indirect controller. HZZL. MA may require information from the controller to make sure that the person is acting prudently. If somebody is no longer a controller, then the MA must be notified within 14 days. Subdivision 4. Restrictions regarding shares in licensee. Under Subdivision 4, we are talking about the following. That is, for majority and minority shareholder controllers, if they want to have transactions in their shares, they have to subject themselves to certain restrictions. ZZN. If a controller of a licensee has become a controller, and if he would like to sell or transfer his shares, MA may, in relation to the transfer of such shares, issue an instruction or impose certain restrictions. In this case, that controller cannot go against the restrictions, because in this way the MA can know who is the controller and will be made aware of the transactions. The MA may also revoke notice given to certain controller under Section HZZN2. You find it in HZZO. The restrictions may be revoked. HZZP, if the shares are subject to a restriction in the notice of the MA, if there is still an agreement to transfer the shares, then the transfer agreements will not be valid, because without the approval of the MA, without the agreement of the MA, the shares cannot be transferred. So this is to override any agreement. So the agreement will be void. HZZQ. Mr. Sin Chung Kai.
So you are copying the existing banking ordinance? Well, I think these companies are listed companies. The transaction of shares cannot be restricted. Under what circumstances can you restrict them? Unless they are suspended from trading. In 8ZZM, it says the controlling shareholder is the majority shareholder, and the minority shareholder that has more than 10%. The minority shareholder is 10%, more than 10%, between 10 to 50%. The majority is 50% or more. If that company is listed, that's just the majority shareholder. So in the listing process, it's hard to have more than 10%. So in 8ZZN, the extra restrictions imposed by a monetary authority, they can allow the free buying and selling of shares. This would involve the listing requirements. So in ZZN, it doesn't restrict transfers, but regarding the transfer of certain shares, there can be restrictions. So when the bank is put up for sale, it has to be authorized by the monetary authority. The owning family might not be a majority shareholder, but it can. There's a material transfer of controlling interest. They have to notify the monetary authority. Some authorized institutions are also listed companies. So if any shareholder has more than 10% of shares, when they wish to transfer shares, they have to see whether there are restrictions on the shares. They have to comply with restrictions. If they do not comply with restrictions, then in 8ZZQ, if they knowingly know that the shares cannot be transferred easily and they still transfer, then they are in breach of minority and majority controlling shareholder restrictions, and there are penalties. It's the same as the banking ordinance. 8ZZR, ZZSSS, 8ZZT are the same as the banking ordinance. So when necessary, the monetary authority can apply for orders from the court of first instance regarding the transfer of shares. There can be restrictions. So any restricted person, when necessary, the monetary authority can seek instructions from the court of first instance. ZZR and SR is copied from the banking ordinance. ZZT says when the court of first instance can make an order, and order some shares can be transferred and some cannot be transferred, then in the specified time the courts have the relevant powers to make valid instructions. Next, we move on to 8ZZU, the appointment of chief executive and senior managers. Just now we talked about the regulatory framework of shareholders. Also, aside from shareholders, we also have senior management, the CEO, and so on. In subdivision 5, we deal with that. In 8ZZU, it says the appointment of chief executive of licensee has to be appropriate and has to be normally residing in Hong Kong, and there can also be a standing acting CEO when the CEO is absent from Hong Kong or is precluded by illness, and we need to have the approval of the monetary authority. If anybody without the approval of the monetary authority acts as CEO, that is a breach of the law. So the monetary authority needs to deal with that. In ZZW, the monetary authority may give consent to a fit and proper person to act as CEO before approval is given, and regarding the approval, they can also impose certain conditions. In dealing with these permissions, we do have procedures where anybody, whether we agree or disagree, we'll give them sufficient time for oral submission. If they disagree with the proposed conditions, they are given a submission opportunity. And the monetary authority can have a final ruling. In 8ZZX, the monetary authority may require information from chief executive or director of licensee, and to also determine whether they should approve the person to become a CEO or director, or whether that permission should be revoked. Moving on to ZZY, appointment of manager. The manager, this is a lowercase m. It refers to the company's the licensee, we have the lowercase manager referring to senior officials of the company in important departments. These are senior managers. The manager you can refer to as page 456 in the Blue Bill, Schedule 6. We also drew reference from the banking ordinance. We feel that some departments are important for the operations of the licensee, including the accounting system, the accounting department, risk control, the risk management, or the department handling money laundering or terrorist financing, the computer system, or the people responsible for internal audits. Under this legislation, these people are called the lowercase managers. So this manager, these managers, the appointment of these managers have to be, the monetary authority has to be notified, and when necessary, the monetary authority will also have to deal with whether these managers are appropriate. So the MA has to be notified. If the MA is not notified, there are penalties. This is such that the monetary authority can grasp, can have an understanding of the operations and quality of staff at the management level. Chairman, These are long-standing powers. I have no question. But regarding the business, these payment systems, there's a huge focus on IT security. So in your appointment, do you have requirements that the bank or the licensee, do they need a security official? Do you think it's necessary? So when incidents occur, there's someone to answer your questions. The CEO might not be conversant with the IT. In Schedule 6, we have stated that this risk control, risk management, or terrorist financing, money laundering, or the person responsible for the computer system, these are the managers. The appointment of managers do not need the approval of the MA, but the MA needs to be notified, so they know that when incidents occur, who is in charge of the affairs. They also have to undertake certain responsibilities. Now, Mr. Sin Zhongkai referred to security. That's a very broad term, but it can include terrorist financing, money laundering, internal audit, risk control, and so on. So this is included in Schedule 6. So we feel that is sufficient to cover all security-related work. I just want to focus on IT security. Well, IT security in point 4 of Schedule 6, the development, operation, and maintenance of computer systems should include the IT security. Well, banks certainly face more risks than a payment system. The banks have to rely on the computers for settlement. When they press a button, it can affect sums up to 7, 8 digits. Well, clauses 3, 4 refer to temporary appointment. So how do we determine whether it's a temporary appointment? That's if the appointment is not permanent, it's just temporary, then it's because there might be some personnel change. So we have included this clause, that is, if it is a short-term appointment, we will have a special procedure. Well, time is almost we still have 2 more clauses, and then we can start with exemptions on the next occasion. 8ZZZ and 8ZZA make reference to Section 73 of the Banking Ordinance. They require employees of the licensee, if there is any insolvency or debt restructuring, or if there are some convictions of fraud and so on. So these employees, or the employment of these employments, need to have approval from the monetary authority. So the MA for existing staff under 8ZZA, if they are insolvent, or if they have debt restructuring, if they are bankrupt, or if they commit fraud or dishonesty, they also need to have the approval of monetary authority to continue to act as employees of the licensee. This is to ensure that the staff can meet the highest requirements, and there is no incentive for them to embezzle funds, and to ensure there is no risk. Well, this is applicable for banks, so we feel that the industry is very clear about this. Okay, let's stop here, and then next meeting is 26th of May, 4:30. Thank you, Chairman.